Picture this. A cold night. Somewhere out past the edges of Sydney, it's pitch black, pre-dawn. Someone's scaling a fence onto a rural property. But this isn't, your typical break-in. This person is an investigator working undercover for an animal welfare group.
Right, and their goal was pretty specific.
Exactly. To get proof of something brutal, something outlawed for decades in New South Wales. Live baiting in the Greyhound industry.
Using live animals to train racing dogs. Horrific stuff.
So this investigator, codename filmmaker, later on, slips in, sets up a hidden camera near a training ring, a bull ring. And what that camera captured, well, it was grim. Grainy footage, sure, but unmistakable. Live rabbits, maybe a possum, tied to lures, attacked by greyhounds. Blooding, they call it.
Yeah, a practice meant to make the dog's chase harder, essentially. Banned since, 1967 in NSW.
That's right. And this covert footage, obtained completely illegally, mind you. It didn't just expose a secret, it blew up into a national scandal.
It really did.
Sure.
Rocked the whole industry.
And it led directly to serious animal cruelty charges against two trainers, Zeki Kadir and his assistant, Donna Grech.
But here's the twist, right? The evidence that could nail them. The videos. It was all obtained by breaking the law. No warrants, no police involvement initially. Just a private investigator, trespassing, secretly recording.
Exactly, which set up this huge legal fight.
Absolutely. It became this fundamental question for the courts. Can you use evidence in a trial if it was gathered illegally? Like, when does the need for justice outweigh the need to uphold the law itself?
It's a massive dilemma, balancing the horror of the alleged crimes against the principle that the state or even private citizens shouldn't break the rules to get a conviction.
In this case, Kadir v. the Queen forced the highest courts in Australia to really grapple with that. The outcome set some major precedents.
So that's our deep dive today. We're going to follow this story from those paddocks, through the courtroom battles, right up to the High Court. We'll look at the key players, the legal arguments.
Yeah, and specifically how the case moved through the system, who argued what, who decided what, and crucially, how it changed Australian evidence law.
Okay, let's get into it. Like any good drama, especially one with hidden cameras and legal showdowns, you need to know the cast of characters. Who are the key people in this real-life story?
Definitely. Let's break down the main figures involved, based purely on what the source material tells us. First, you have the two people facing the charges, the appellants later on, Zeki Kadir and Donna Grech.
Kadir was the main guy.
Seems so. Described as a veteran Greyhound trainer, ran the whole breaking-in facility at a place called Wilshire Park, west of Sydney. That's where the alleged cruelty happened.
The blooding.
Exactly. The accusation was he used live animals, rabbits, maybe a possum, to train young greyhounds. Again, something illegal in NSW for a very long time.
And he faced serious charges.
13 counts of serious animal cruelty under the NSW Crimes Act, Section 530. He pleaded not guilty the whole way through.
Okay. And Donna Grech.
She was Kadir's employee, his assistant trainer at the facility. Also charged under the same law, faced 12 counts. And like Kadir, she pleaded not guilty.
Right. Then there's the person who got the footage.
Sarah Lynch. The sources describe her as a photographer who became an investigator for Animals Australia. She's the one who went undercover.
Posing as a dog owner?
Yeah, pretended she wanted her greyhounds trained there. That's how she got access. Planted hidden cameras, audio recorders over weeks. Got 7 videos, 2 audio recordings.
The filmmaker codename.
That's her. Her actions obviously were central. Got the evidence, but did it illegally trespass unlawful surveillance. Raised huge questions about vigilantism, privacy, the works.
Which brings us to the organization behind her.
Animals Australia, the animal rights group that hired Mrs. Lynch. Their stated goal includes investigating animal cruelty. The key figure there who testified was Mrs. Lynn White, their chief investigator and campaign director.
Did she have a background in this sort of thing?
She did have prior police experience in South Australia, some involvement with surveillance warrants back in the 80s and 90s. But she testified that, in her view, authorities wouldn't act on just an anonymous tip for something like this.
So she felt they had to do it themselves.
That was her explanation. Concerns about tip-offs, the belief it was widespread, lack of successful prosecutions, essentially a feeling that the system wouldn't work, so they bypassed it. Notably, they had lawyers available but didn't consult them before the operation.
Okay. And who brought the actual charges?
That's the Crown representing the state of New South Wales. So the NSW police investigated after getting the evidence, and the Director of Public Prosecutions, the DPP, formally prosecuted the case.
They had a tricky situation, though.
Definitely. Their key evidence was tainted from the start because of how Lynch obtained it. Their argument was basically, the cruelty is so bad, the public interest demands we use this evidence, even if the methods were questionable. Experienced Crown prosecutors, like H. Baker SC, argued this later on. SC is meaning senior counsel, by the way.
And fighting against the Crown.
The defense counsel for Kadir and Grech, initially supported by Legal Aid NSW. Their absolute goal was to get all that covert evidence thrown out. Videos, recordings, anything that flowed from it.
Their argument being
that admitting it would basically endorse illegal vigilantism. You can't have private groups breaking the law to enforce it, they argued. It undermines the whole system, the rule of law. They knew if they got the evidence excluded, the case would likely collapse.
Who were the key lawyers for the defense?
A number were involved at different stages. The sources mention veteran criminal lawyer Tim Game SC, also Kate Lindemann and Mr. D.P. Hume, and solicitor Michael Bowe represented one of the appellants. They were determined.
And finally, the ones making the decisions.
The judges. At the first stage, the pretrial hearing in the district court, it was Judge Mark Buscombe. His job was to make that initial call on whether the evidence was admissible under Section 138 of the Evidence Act.
And when his decision was appealed?
It went to the NSW Court of Criminal Appeal, the CCA. 3 judges heard that. Justices Ward J.A., Price J., and Beach Jones J. J.G. means Justice of Appeal.
And the final stop.
The High Court of Australia. The ultimate appeal. 5 judges made the final landmark decision. Chief Justice Kiefel and Justices Bell, Keene, Nettle, and Edelman.
And it's crucial to remember, right, their job wasn't guilt or innocence?
Absolutely not, especially the appeal courts. Their focus was purely on the legal question. Could this evidence, obtained the way it was, be legally used in a trial? That was the entire fight at the appellate level.
Okay, so we know who's who. Let's trace the timeline now. How did this all unfold from that first tip-off to the courtroom door? Can you walk us through the procedural steps?
Sure. It all picked off, according to the sources, with an anonymous complaint. Someone contacted Animals Australia in November 2014, alleging live baiting was happening at Kadir's place, Wilshire Park.
That was the spark.
Right. Mrs. Lynn White at Animals Australia got this tip and decided to investigate. She brought in Sarah Lynch, the investigator.
And the covert operation began when?
December 5th, 2014. That's when Lynch first went onto the property. Trespassed, actually, on Kadir's land and a neighbor's to position that hidden camera near the bullring fence.
And that act itself was illegal?
Yes, straight away. Installing and using that camera without consent breached Section 8.1 of the NSW Surveillance Devices Act 2007. That's the SDA. A critical point.
She got footage that first night.
Well, she retrieved the first recording the next night, December 6th. And yes, the evidence presented later showed that initial footage did appear to support the allegations. It captured activity consistent with live baiting.
Okay, so they have some proof now. Did they immediately call the cops or the RSPCA?
No. And this became a major focus in court. Ms. White testified they didn't go to the authorities right away after getting that first video.
Why not?
Her reasoning, as presented, was multifaceted. She felt they needed more to see if it was a pattern, identify other trainers possibly involved. Plus, her assessment, right or wrong, was that authorities wouldn't get a warrant on just that initial bit from an anonymous tip, and she feared leaks.
So she sent Lynch back in.
Correct. Even knowing the recording contravened the SDA, the instruction was to get more footage.
How many times did Lynch go back?
The evidence points to 11 more entries onto the property between December 2014 and January 2015. Repeated trespass, repeated breaches of various sections of the SDA, installing, using, maintaining the devices. She ultimately obtained 7 video recordings in total.
So multiple illegal acts over weeks.
Yes. And Animals Australia's justification, again based on Ms. White's testimony, was this perceived necessity, fear of tip-offs, belief it was systemic, doubts about authorities acting effectively or having the right powers, like the RSPCA's limited surveillance abilities compared to police. Although the RSPCA chief inspector later testified they would investigate such complaints.
When did they finally involve the RSPCA?
Formally, on February 2nd, 2015, they contacted the RSPCA, said they had evidence of criminal acts, but admitted they'd had, quote, difficulties obtaining it legally. They handed over a hard drive with the raw footage.
And the RSPCA took it from there?
Yes. Once they had that information and viewed the footage, they decided to launch their own official investigation. Critically, based on that illegally obtained footage, the RSPCA was able to successfully apply for a search warrant under the Prevention of Cruelty to Animals Act.
So the warrant itself was technically legal, but prompted by illegal evidence?
Precisely. That's the fruit of the poisonous tree issue rearing its head. The RSPCA, along with NSW police, executed that warrant on February 11th, 2015.
What happened during the raid?
The sources say they found the front gate locked, so they jumped the fence, went down to the bullring area. They found and seized physical evidence, training gear, animal carcasses, things consistent with the allegations, all logged as search warrant evidence.
But there was another layer to Lynch's investigation, wasn't there? The alleged admissions.
Yes. After seeing the initial footage, Mrs. White also tasked Lynch with finding out who else might be using Kadir's services. So Lynch went back to the property on January 13th and 18th, 2015, but this time not to plant cameras.
What was her role then?
She was posing as a potential client, engaging Kadir in conversation, pretending she wanted her dogs trained there.
And that's when Kadir allegedly talked.
According to the recordings made during those conversations, yes. On January 13th, Kadir allegedly made admissions about using live rabbits, claiming he used 30 live rabbits a week and describing it as a coursing sport.
Did she use the illegal videos to get him to talk?
That's a key point the courts looked at later. No, the evidence indicated she didn't mention or leverage the footage. She just played the role of a customer, and he allegedly boasted about his methods.
And then came the public explosion.
Huge explosion. February 16th, 2015. ABC's Four Corners program aired Making a Killing, broadcasting parts of Lynch's hidden camera footage. Edited, yes, but still shocking. It caused immediate, widespread national outrage, huge public pressure, condemnation from politicians, racing bodies, everything kicked into high gear.
So the evidence is out there, public fury is immense, charges are laid, but that legal problem of how the evidence was gathered just wouldn't go away. It all comes to a head in court, right? This pretrial hearing.
Exactly. The case landed in the NSW District Court, and before any jury trial could even be considered, they had to resolve this fundamental issue. Could the prosecution actually use the videos, the admissions, the stuff found in the raid? This happens in what's called a voir dire, a sort of mini-trial focused just on the admissibility of evidence.
And the law they were looking at was Section 138.
Section 138 of the Evidence Act 1995 NSW. That's the crucial piece of legislation here. It deals specifically with evidence obtained improperly or illegally, or evidence found because of some earlier impropriety or illegality.
What does it actually say? Can you just never use illegal evidence?
No, it's not an automatic ban. Section 138 says such evidence is not to be admitted unless the court decides that the desirability of admitting it outweighs the undesirability of admitting evidence obtained that way.
A balancing act.
A very careful balancing act. The court has to weigh up competing public interests. On one hand, you want the truth out, you want serious crimes prosecuted. That's the desirability side.
And the other side?
The undesirability. That's about discouraging illegal conduct by investigators, protecting people's rights, maintaining the integrity of the justice system. You don't want courts seen to be approving of lawbreaking, even for a good cause.
Does the law give hints on how to balance it?
Oh, yes. Section 138 lists factors the judge must consider. Things like, how serious is the crime being prosecuted? How important is this piece of evidence to the case? What was the nature of the illegality used to get it? Was it deliberate or just accidental? Was it easy or hard to get the evidence lawfully? And critically, would admitting the evidence encourage more illegal conduct in the future?
Okay, so the defense lawyers, Tim Game SC, Kate Lindemann, Mr. Hume, with Michael Bowe as solicitor, what was their argument under S-138?
Their argument was simple. Exclude everything. The videos, the admissions Kadir allegedly made to Lynch, even the physical evidence found by the RSPCA during the raid, they went hard on the undesirability factor.
How so?
They stressed that Animals Australia's actions weren't a mistake. They were willful and deliberate violations of the law. Trespass, multiple breaches of the Surveillance Devices Act, done consciously by their chief investigator.
And repeated violations, too.
Exactly. Not just once, but 11 entries. They argued this showed a blatant disregard for the law. They also hammered the point that Animals Australia intentionally bypassed lawful channels. They didn't try to work with police or RSPCA first, despite having Mrs. White's background and access to lawyers. They chose to break the law.
Vigilantism, essentially.
That was the core of their public policy argument. Admitting this evidence, they said, would give curial approval, judicial approval to this kind of illegal vigilantism. It would tell private groups, go ahead, break the law if you think it's important, which undermines the whole legal system.
And they linked all the evidence together.
Yes, the poison chain, or fruit of the poisonous tree argument. They argued the illegal videos were the poison, and everything that followed the RSPCA warrant, the admissions Lynch caught later, was fruit from that poison tree. If the initial act was illegal and unacceptable, everything derived from it should also be unacceptable.
So what did the Crown, the prosecution led by people like H. Baker SC, argue back?
They focused on the desirability side. First and foremost, the sheer gravity of the alleged crimes. This wasn't minor stuff, it was serious animal cruelty. Huge public interest in seeing it prosecuted.
Did they address how hard it might have been to get the evidence legally?
Yes, that was a key point for them, linking to S-138, the difficulty factor. They argued it would have been incredibly hard, maybe impossible, for police or RSPCA to get this kind of covert video evidence legally. RSPCA didn't have the power. Police might not have had resources or grounds for a warrant based just on an anonymous tip for a remote location.
So a kind of necessity argument, even if the action was illegal.
Sorta. That without the activists stepping outside the law, this cruelty would just continue unseen. They argued S-138 wasn't meant to let serious offenders walk just because a civilian broke a rule trying to expose them. They also tried to argue the causal links weren't as strong as the defense claimed, particularly for the admissions and search evidence.
Okay, so you have these powerful competing arguments. How did the first judge, Judge Buscombe, in the district court, rule?
Judge Buscombe heard all this in the voir dire and delivered his ruling on June 28, 2017. He applied the S-138 balancing test. He agreed the alleged animal cruelty was serious point for the Crown.
Right.
But he found the illegality by Animals Australia was also extremely serious. He described their contraventions of the SDA and trespass laws as very high and serious. He emphasized they were deliberate, repeated 11 times, and decided upon by a chief investigator who, in his view, made zero effort to try lawful methods first.
What about the difficulty argument?
He found that hard to weigh because, as he saw it, they hadn't actually tried the lawful route. He thought maybe covert surveillance could have been attempted by authorities if they'd been brought in earlier.
And the public policy aspect. Vigilantism.
That weighed very heavily for Judge Buscombe. He stressed the importance of courts not lending judicial integrity or curial approval to deliberate law-breaking by private groups operating outside the rules. He felt admitting the evidence would risk encouraging that kind of conduct, undermining the rule of law.
Did he buy the poison chain argument?
Yes, he found a direct causal link, but for the illegal recordings, the RSPCA wouldn't have got the warrant, and the admissions likely wouldn't have occurred in the same way. Since he found the videos inadmissible due to the serious illegality and policy concerns, he ruled that the search evidence and admissions were also tainted and therefore inadmissible.
So the final decision from Judge Buscombe.
Exclude everything. All the videos, all the admissions, all the physical evidence from the RSPCA raid. A complete wipeout for the prosecution's case based on that evidence.
Wow, that's huge. It basically stopped the prosecution cold, didn't it? Looked like Kadir and Grech were off the hook. But you said the Crown wasn't done yet. What happened next?
That's right. It was a massive blow, but not the end of the road. The DPP has a specific power in NSW under Section 5F3A of the Criminal Appeal Act to appeal these kinds of pre-trial evidence rulings if they basically gut the case. And this ruling definitely did that. So the Crown appealed to the NSW Court of Criminal Appeal, CCA.
So round two. Who were the lawyers arguing this time?
Before the CCA judges Justices Ward, Price, and Beach-Jones, you again had the Crown, likely still led by senior counsel like H. Baker SC, arguing against the defense team, including Tim Game SC and Kate Lindemann.
Did the Crown change their strategy on appeal?
They seemed to refine it, yeah. They appeared to somewhat concede on most of the videos, maybe realizing the repeated entries were a big problem. But they pushed hard on 3 specific things.
Which were?
First, they argued the very first video from December 5th should be admitted, even if the others weren't. Second, the RSPCA search evidence. Third, Kadir's alleged admissions to Lynch.
What was their logic for separating these out?
For the first video, maybe an argument that it was the crucial proof of concept needed to involve authorities. For the search evidence and admissions, they really tried to break that poison chain idea. They argued the connection, the causal link back to the initial illegal filming was weaker or attenuated.
How so for the search evidence?
They stressed the RSPCA acted totally lawfully when they got and executed the warrant. The illegality was by Animals Australia, a third party. The authorities themselves didn't do anything wrong in the search itself.
And for the admissions?
The argument was that Lynch wasn't using the illegal footage when she got Kadir to talk. She was in a different role, potential customer. He chose to talk. So admitting the confession wouldn't be rewarding the illegal filming.
So how did the CCA judges rule? This was November 2017.
November 30th, 2017. And they partially agreed with the Crown. They found Judge Buscombe had made an error, mainly by not properly considering the evidence piece by piece, especially that first video.
So they let some evidence back in.
Yes. They redid the S-138 balancing test and came to different conclusions on some items. They ruled the first covert video was admissible. The other 6 remained out.
Okay, one video back in. What about the raid evidence?
Also ruled admissible. The CCA agreed with the Crown's reasoning here. The RSPCA acted under a lawful warrant, their actions were proper, and this sufficiently broke the chain from the initial private illegality.
And the confessions.
Also admissible. The CCA found the causal link between the illegal filming and the admissions was, quote, tenuous. They accepted Lynch was in a different role, not leveraging the footage, and Kadir spoke freely, admitting the confession they felt didn't endorse the unlawful surveillance.
Right, so the CCA decision dramatically revived the prosecution's case. They now had the first video, the physical evidence, and Kadir's own words. That must have felt like a huge win for the Crown.
It was definitely a major turnaround from the district court ruling. The case was suddenly viable again.
But the defense wasn't giving up either, were they? They took it higher.
They absolutely did. Kadir and Grech sought and got special leave to appeal the CCA's decision to the High Court of Australia, the final legal battlefield.
And who argued before the High Court Justices Kiefel, Bell, Keene, Nettle, and Edelman?
Representing Kadir and Grech, the appellants, were, again, Tim Game SC, Kate Lindemann, and Mr. D.P. Hume, with Michael Bowe as solicitor. For the Crown, the respondent, it was H. Baker SC.
What was the core defense argument this time? Still focused on vigilantism.
Very much so. Tim Game SC, for the appellants, really zeroed in on how the CCA had supposedly misapplied the S-138 balance, specifically arguing they hadn't given enough weight to the danger of curial approval or encouragement of unlawful conduct. That phrase, curial approval, was key.
Meaning the court stamping its approval on the illegal methods.
Exactly. Game SC argued that if the CCA decision stood and evidence obtained this way was allowed in, it would send a green light to activists everywhere. It would basically say the courts will let you use illegally obtained evidence if the cause is worthy, which, he argued, fundamentally undermines the rule of law.
What about the difficulty of getting evidence legally? Did he address that?
He did. He acknowledged it might be difficult, but argued that's not the court's problem to fix by bending evidence rules. If laws make it too hard for police, that's for Parliament to change, not for courts to solve by allowing illegal evidence from private citizens. His stance was firm. Uphold the process, even if it's hard.
And the Crown's response at the High Court?
H. Baker SC maintained the arguments that succeeded at the CCA. Emphasized the necessity aspect that conventional methods likely wouldn't have worked, stressed the weak link between the illegal filming and the later admissions, obtained via deception, not leveraging the footage, and reiterated that the RSPCA acted lawfully in the search, so that evidence shouldn't be excluded just because of the activists' earlier actions.
Before we get to the final decision, wasn't there a side issue about keeping the case quiet? A non-publication order?
Ah, yes, good point. Before the main High Court hearing on the evidence, the appellants applied for a non-publication order. They wanted to stop the media reporting on the High Court proceedings and their names, arguing it could prejudice a future jury trial.
Who argued that?
Their barristers, Mr. Reynolds and Mrs. Lindemann, supported by an affidavit from solicitor Michael Bowe. They were worried the detailed legal analysis of the evidence, even just its admissibility, would taint the jury pool. The Crown, represented by Mr. Baker for this application, was neutral.
What happened with that?
Chief Justice Kiefel dismissed the application back in July 2019. She basically said the trial judge could manage any potential prejudice through jury selection and directions. Standard practice, really. Faith in the trial process to handle pre-trial publicity.
Okay, so back to the main event. The High Court's final decision on the evidence. When did that come down?
February 5th, 2020. The judgment known as 2020 HCA 1. And it was fascinatingly nuanced.
Did they agree with the CCA? Or Judge Buscombe?
On the surveillance video footage, they sided with the original trial judge, Judge Buscombe. They overturned the CCA and ruled that all the secret videos must be excluded, even the first one.
Why? Back to the vigilantism point.
Precisely. They weighed the S-138 factors and came down hard on the side of deterring illegal conduct and avoiding that curial approval. The illegality, deliberate, repeated SDA breaches, trespass was just too serious. Admitting the videos, they said, would give a curial nod to vigilantism. They also made a point that when illegality is deliberate, the difficulty of obtaining evidence lawfully factor usually weighs against admission, not for it.
Okay, so NO videos. What about the evidence from the RSPCA raid?
Here, they agreed with the CCA. The search warrant evidence was admissible.
Even though it came from the illegal videos?
Oh. Yes. Their reasoning was key. The RSPCA acted lawfully under a proper warrant. They weren't involved in the initial illegality. There wasn't a pattern of RSPCA relying on activists' illegal work. So the desirability of using this important evidence for a serious crime outweighed the undesirability flowing from the private initial illegality, which was now somewhat distant or attenuated by the lawful police action.
Interesting distinction. And Kadir's alleged admissions.
Also admissible, agreeing again with the CCA. They found the causal link between the illegal filming and the confession was weak or tenuous.
Because Lynch was playing a different role.
Exactly. She didn't use the illegal footage to get him to talk. She used deception, posing as a customer. He chose to boast. Admitting this confession, the High Court reasoned, didn't risk encouraging illegal surveillance in the future because the confession came from the deception, not directly from the SDA breaches. It didn't give curial approval to the specific illegality they wanted to deter the filming.
Wow. So the High Court drew this really fine, intricate line. No illegal videos that encourages vigilantism. But yes to evidence found later by lawful authorities, and yes to confessions obtained by other means, even if linked loosely to the initial illegal act. That's complex.
It is incredibly complex, but also incredibly significant.
So what's the lasting impact? How has Kadir v. the Queen actually changed things in Australian law?
Its impact is huge. Kadir is now the benchmark case for Section 138 of the Evidence Act, referenced constantly by lawyers and judges across Australia whenever evidence might have been obtained improperly or illegally.
The main message seems to be about vigilantism.
That's definitely one major takeaway. The flat rejection of all the videos sends a very clear message. If private citizens or groups deliberately break serious laws like surveillance acts and trespass to get evidence, they cannot expect the courts to admit it. It reinforces that the ends don't justify the means, and courts won't give that curial approval to vigilantism. It's a strong deterrent.
But it's not a total ban on anything connected to illegality.
No, and that's the crucial nuance. The admission of the search evidence and confessions shows Australia doesn't have a strict U.S.-style fruit the poisonous tree rule where any downstream evidence is automatically out.
So evidence obtained because of earlier illegality can sometimes get in.
Yes, Kadir clarifies it can, but only after careful balancing under S-138. It might be okay if the causal link is weak, like the admissions, or if the evidence was later obtained properly by authorities who weren't involved in the initial wrongdoing, like the RSPCA search. The public interest in prosecuting serious crime can still win out, especially if the illegality was by a private party and the later steps were lawful.
Does this apply beyond animal cruelty cases?
Absolutely. The principles apply to any situation where evidence is obtained improperly by private parties. Think illegally recorded conversations, hacked documents, unauthorized photos. Courts facing those issues will now look directly to Kadir for how to apply S-138.
So it really highlights Australia's approach.
Definitely. It showcases the flexible, discretionary approach under S-138. Judges have to weigh everything up: the crime severity, the illegality's severity, how deliberate it was, the difficulty of lawful means, the risk of encouraging bad behavior. Kadir is the masterclass in how that balancing act works.
It really is a case that put the legal system in a tough spot, wasn't it? Trying to balance justice for the animals against upholding the integrity of the whole legal process.
A very tough spot. It forced a confrontation with uncomfortable questions about means versus ends, truth versus process.
And the High Court's final answer was this carefully drawn line. No illegal videos, but the lawful search findings and the confessions obtained differently were okay.
That was the resolution of the S-138 balance in this specific, highly charged case. No reward for the illegal surveillance itself, but not automatically discarding other evidence that had a weaker or more attenuated link to that initial illegality, especially when authorities acted lawfully later on.
And the echoes of Kadir are felt every day in Australian courts now. A real reminder of the risks of taking the law into your own hands and the challenges of investigating hidden crimes within the rules. It's a legal drama with lasting consequences. So reflecting on all this, here's a final thought for you to consider. Investigating hidden crimes like live baiting is undeniably difficult, using only lawful means. Did the High Court in Kadir strike the right balance with Section 138? Did they manage to deter illegal evidence gathering effectively while still leaving the door open just enough to prosecute serious crimes using other evidence? What's the most important lesson you take away from this whole saga? Thanks for joining us for this deep dive into the complexities of Kadir v. the Queen.